Assalamualaikum. Presentation Journal Review of Legal Maxim. Our group Afizuddin, Zayana, Adila, Faizul Hakim, Aisyah, Fahmi. The title of the journal, The Legal Maxim of Islamic Law, excluding 5 leading legal maxim and their application in finance.
Literature review, legal maxim in Islamic finance, and conclusion. Next, in introduction, al-qawaid al-fiqhiyah or legal maxims are general rules of fiqh which can be applied in various cases that come under the common rulings. These legal maxims play an important role in the formulating of Islamic law, for they are used as principles to deduce many rules of fiqh. The word of al-qawaid is the plural of al-qaidah, which means principles, and fiqh means Islamic law. Therefore, generally, al-qawaid al-fiqhiyah means the principle of Islamic law. There are 5 leading maxim as reflected in the majalah, such as al-umur bi maqasidiha, al-yakin la yazul bi al-shak, al-masyaqqah tajlil at-taysir, ad-darar yuzal, and al-adah muhakkamah. For literature review, first, al-qawaid al-fiqhiyah were not written all at once by a particular scholar, but were developed by jurists at the time of the resurgence of fiqh. Among the earliest of the jurists to develop most of the fiqh maxim are the jurists from Hanafi school. As for the author of this maxim, most of them are not known except for those maxim originally deduced from saying of the Prophet or attributed to particular scholars. An early Iraqi jurist, Abu Tahir Muhammad bin Muhammad Sufyan al-Dabas, collected the first 70 maxims, and his contemporary Abu al-Hasan Ubaidillah ibn al-Husain al-Kharki increased this to 39. Al-Kharki work, entitled Usul al-Kharki, is regarded as an authoritative Hanafi precursor on legal maxim. Some have regarded it as more of a work on usul fiqh. Al-Kharki collection commences with the first aslu, what is proven with certainty is overruled by doubt, and it finishes with the aslu that explanation to a speech is credible for as long as it is given a time when it can be considered valid, but not otherwise. Classification of legal maxim. Legal maxim can be categorized into different classification, which is the scope of the qawaid in terms of its application towards the issue of fiqh and the acceptance of a particular maxim among the different schools of Islamic law. Okay, scope of application to issue of fiqh. The classification of legal maxim. Legal maxim can be categorized into 2 different classifications, which is the scope of the qawaid in terms of its application towards the issue of fiqh, and second is the acceptance of a particular maxim among the different schools of Islamic law. Scope of application to issue of fiqh. The major maxim that cover various of issue fiqh, the type of legal maxim that cover a substantial amount of fiqh subject. However, the coverage is lesser compared to the above category. Acceptance of a particular maxim among the scholar, maxim which are accepted and utilized by all scholars from different school of Islamic law. Legal maxim, they are accepted by certain scholars from certain mazhab but rejected by others. The 5 leading maxim and their branches. First, matters are determined according to intention, which al-umur bi maqasidiha. Second, hardship begets facility, al-masyaqqah tajlib at-taysir. Third, harm must be eliminated, ad-darar yuzal. Number 4, certainty is not overruled by doubt, al-yakin la yazul bi al-shak. And lastly, custom is a basis for judgment, al-adah muhakkamah. Except 5 of the main maxim cover a substantial amount of fiqh subject, but to a lesser extent compared to the above category. As example, ad-darurat to be al-mahzurat, which means necessity render prohibited things permissible, is derived from the major maxim mentioned above, which say al-masyaqqah tajlib at-taysir, which is hardship begets facility. For legal maxim in Islamic finance, first, in contracts, attention is given to the object and meaning and not to the word and form. For the application in Islamic finance and banking, by al-wafa is basically a sale of commodity on the condition that the seller be allowed to buy back the commodity upon paying its price. This transaction is perceived by the majalah as a pledge contract, not due to the form reflected in the offer and acceptance, but rather the intention and substance as reflected in the earlier maxim. Second, necessity, which is darurat, make the forbidden things canonically harmless. For the application in Islamic finance and banking, by salam and istisna, even though they run counter to the rule of the sale of a non-existing commodity, the purpose of the realization is to overcome the obstacle in the smooth economic functioning of the society. Severe damage, darar, is made to disappear by a lighter damage. For the application in Islamic finance and banking, financial institution is forced to lay off some employee or close branches to remain in business. It may do so since the harm of an insolvent institution is more severe than the suffering of a smaller number of employees. Number 4, when the receiving of a thing is forbidden, the giving of its Number 4, when the receiving of a thing is forbidden, the giving of it is also forbidden. For the application of Islamic finance and banking, this maxim is applicable to financial transactions like taking of interest and illegal gratifications. Also, it applies to the giving or receiving of bribes. There are some dalil from Al-Quran and Hadith that prove statement above. 5, begets risk. For the application of Islamic finance and banking, this legal maxim invokes to invite people to participate in ventures involving both risk and reward, such as al-bay' al-ijarah, salam, mudarabah, and musyarakah. Claim what is permissible in law cannot be cause for a liability. For the application in Islamic finance and banking, an Islamic government provide the best available transport facility to its citizen. If somehow an individual is harmed by this development, the government will not be bound to compensation that person. In conclusion, the story of legal maxim clearly shows that they have been regularly applied not just in the law of Badah and family law, but also extended to the role of finance. The development of Islamic banking, finance and insurance have also witnessed a revival of the Sharia law of muamalat, especially in the current financial situation. There is substantial need for the maxim to play their role in strengthening Islamic finance. Islamic jurists surely contributed enormously and continue to provide an important role in deriving rulings that involve this important legal maxim. After the primary sources, the Al-Quran and As-Sunnah.
That's all from us. Thank you.